Thank you very much, and good afternoon. Welcome to all participants in the webinar on synergies between anti-corruption and antitrust compliance. My name is Annette Schild, and I'm a partner in the Antitrust group of Arnold & Porter. I can tell you right away, I'm the only antitrust lawyer around, and so I'm the one who very much looks forward to learning from our colleagues on the panel today. Before we start off, I have a few housekeeping matters, unfortunately. First of all, to those in the room, I should tell you that our microphones are extremely good. We've tested them yesterday. And so if you have phones, I would really ask you to turn them off, because otherwise more than 100 people around the world will listen to your phone call. Then the second, speaking of sounds, I should also warn you, we have organized a very good system to make sure that our speakers don't speak so long. So we will have the bells ringing at the cathedral every 15 minutes. So they know that they are out of time when the bells are ringing. So don't get scared, the people on the phone won't hear that, but just be prepared. The next one, our program, we're really hoping to have this as interactive as possible. So the idea is that we'll have 3 relatively short presentations of roughly 15 minutes each, and then have time to discuss after that. Since the participants in the room here can continue talking to the panelists later, if we get in a lot of questions from the audience on the phone, we would ask you for your understanding that we'll treat those first, because all the panelists will be there later and very happy to answer additional questions. We'll have 2 rounds of questions, one after each presentation, and there I would ask you to limit your questions just to questions of understanding of the presentation, because we're hoping that maybe some other questions we'll answer in the other presentations. And then we'll have a longer period of time after I think around 5:30 after the 3 presentations. Questions from all the participants via the webinar can be typed in, and we'll do our best to respond to all of them. If we do not manage to get through every question, we'll get back to you later. One of the panelists or several of them may answer those questions. Final housekeeping, I know some of you will need CLE or CDP credit, and that means that we will have to send out a questionnaire with a few questions afterwards, because that's the condition for getting that credit. So don't be afraid, we're not examining you afterwards. Now to our speakers. We're very privileged to have among us Guido de Clercq, who is Deputy Secretary General of the GDF Suez Group, where he oversees the group's global compliance policies and organization. Before taking on that role, Guido was Group GDF Suez's General Counsel. But he has not always worked in a company, I saw. Actually started out teaching law in Leuven and also worked as a private practitioner. And he speaks and publishes regularly on compliance matters. So the perfect person to ask questions to, I think. And we're very privileged. We're also very happy to have Kathleen Harris, a London-based partner in our white-collar criminal defense practice, where she represents companies and individuals in criminal investigations and compliance matters in complex economic crimes. Kathleen also advised government ministers on the development and implementation of policy and fraud strategy and leading complex overseas inquiries and analyses. Before joining Arnold & Porter, Kathleen was on the other side. She actually served as head of the fraud business group and head of policy at the Serious Fraud Office, and was senior strategic policy advisor in the Attorney General's office. And last but not least, we'll get to John Nasikas, the global chair of Arnold & Porter's white-collar criminal defense practice, who concentrates on complex parallel criminal and civil litigation and internal corporate investigations. He's been in Washington for about 30 years and has advised and defended companies, executives, as well as employees in a wide array of federal and state criminal investigations. Recently is focused on FCPA global anti-corruption, but also antitrust, healthcare fraud, government contracts, international trade, export control, and public corruption. John's also been on the other side and was at the Department of Justice previously as an assistant U.S. attorney for the Major Crimes Division of the U.S. Attorney's Office for the Eastern District of Virginia. So after all these lengthy introductions, let's get to today's topic, compliance in anti-corruption and antitrust matters. For me, this is a really interesting topic. As I say, I'm an antitrust lawyer, and I've been working on cartel matters for the last 20 years. And my own exposure to corruption came in the first real big cartel case where we were mostly dealing with bid rigging and bid rigging around the world. And I was working on the cartel side, but very soon we realized that the cartel only worked because there was also corruption. Basically, the guys got together, they decided who was going to win the bid, and then they dealt with the various public officials to make sure that the winner would actually win. So not only did we find that out when we looked at all the documents, but we also found out very soon that the whistleblower in the cartel case had done some major cleaning up and had self-reported to the authorities also on the corruption side, which meant that the corruption of the others also was found out, and they thought at some point this was a very big conspiracy to kill the other industry participants. I think it was mostly because they had a new general counsel who was cleaning up the business. But whatever it was quite impressive because I counted something like 27 investigations, about half and half corruption and cartel in basically the same matter. So, and of course now in the meantime, when doing seminars on compliance, I also find that most of the company representatives have a huge amount of experience in anti-corruption matters, and that the two investigations really tend to go together. But finally, let's get to our speakers. We'll hear more about the links between those two areas, first from a somewhat philosophical standpoint, then learn about recent enforcement trends and international cooperation, and get an overview of the synergies between antitrust and anti-corruption compliance in the US and the UK. So Guido, would you like to start on the in-house perspective?
Thank you so much. Good morning, good afternoon, wherever people are located. Privilege for me to address these issues, which, as you will read, are only my proper views, my own views. I will not run through the presentation as such. I will highlight a few points so that you can try to see how, I don't say philosophically, but conceptually, I try to come to terms with compliance. I will focus on the concept of compliance, try to indicate the impact of the compliance approach on some legal concepts, necessitating judicial review. I will try to balance between enforcement and transparency, to make sure that we, at the end of the day, understand that the integrated approach is a mandatory approach which leads us to the way we should structure as companies the compliance programs. On slide 1, I have tried to indicate the basic concept of compliance, which in my reading is less related to values, but more related to the way companies should structure their behavior in line with not only legal requirements, but especially the position taken by compliance enforcement agencies. So my basic position is whatever we do, we are today confronted not only with the legislation, but by the way this legislation is read, interpreted and applied by the compliance enforcement agencies. And if we take that for granted, quote unquote, at slide 3, I then would say if we have this enforcement focus and enforcement agencies, what is their main concern? Their main concern is the behavior offenses. The way we behave both in corruption cases but also in cartel cases. And I think that is a very important way to approach compliance, although I'm not a behaviorist, from a behavior point of view, because at the end of the day people will look into the way our behavior has been structured in line with the way the enforcement agencies ask us to behave. and hence it leads us to what I would say a managerial approach. Compliance officers are important, but by the end of the day, it is middle and top management that carries this burden, with a tool that is basically the way we should behave, i.e. self-monitoring and self-assessment of our conduct, which is both the case in anti-corruption and in competition law matters. From an internal point of view, I would say, and this is a kind of selling line, if we can do business because we have to comply with health and safety requirements, business without human casualties, we should by the same token do business without compliance casualties. Once we have this approach from an enforcement point of view, the question is how can we structure our compliance agenda? And at slide 4, I try to identify the key issues. Compliance today is not just obedience with law. It is more than that. It is also that we have to prevent and detect the violation of law. So we are becoming really private enforcement agencies in line with the way public enforcement agencies look into these matters. So this is a very enforcement-driven approach that imposes on us the way to structure internally matters of preventing and detecting and by definition ending infringements. And therefore, I would say the way to be effective, because the effectiveness is the test that is today the key parameter, and those who are familiar with the position paper by the European Commission on competition law, the Commission has stated effectiveness is the sole benchmark of success. So whatever you do, forget about the rest. Effectiveness meaning, gentlemen, ladies, no infringement whatsoever. So you have this position taken by these compliance agencies, pushing us to mirror their expectations, their objectives, to make sure that at the end of the day, our behavior leads to no infringement. And if we look into this concept, less value-driven and more enforcement-driven, it means, at page 5, that we come to some of these, I would say, boundaries of where we are in the legal system, because this enforcement approach challenges more and more established legal concepts, necessitating, in my view, a much more pronounced legal review, legal oversight by the judicial, by the courts. A few illustrations. In the deferred prosecution agreements, the question to impose corporate monitors rather than asking management to do the job with reporting duty. The extensive interpretation of the parental liability, especially in the European Commission's reading. Page 6, what is common to both the antitrust and the anti-bribery, especially in the United Kingdom, but also in the United States, the focus on individuals, leading to incriminate individuals, directors, officers, without having today any criminal liability on the company. So a very focused approach on individuals. And then an issue which I think is at the heart of the agenda, the fact that today we are credited for cooperation the moment we see or we identify an infringement, but we are not credited for the compliance. And so it means that if there is a trade-off to be done, the question is, should we really invest in compliance, which is a very burdensome agenda for all the legal fields in which compliance is required, or should we be more opportunistic by just saying, if we come across an incident, we will cooperate and so on and so forth, because that is maybe the most efficient way to benefit from the way we can structure our approach with the enforcement agencies. And there I refer to two interesting legal initiatives, the Decree 231 in Italy that gives a kind of benefit exemption from administrative liability, and of course the UK Bribery Act with the adequate procedure. I just refer at page 7 to a report by an independent advisory group who really again put the judicial oversight at the heart of the compliance agenda. So if we see the boundaries and the way the enforcement agencies position themselves, and the difficulty for judicial review in this agenda, the question is, and it's another tendency, can we not approach without leaving? Without putting aside this bribery, hard court bribery approach? Is there no other way to leverage on the behavior through more focus on transparency, which by definition, as you know, is also part of the FCPA approach, books and records provision. I identified on page 8 interesting evolutions where for certain people bribery is one part of the agenda, but state capture by sector becomes a much more important issue which by definition then will lead into more transparency. You have the IMF who is focusing on transparency and the corruption legal framework. But you have also in this respect initiatives taken by certain industries. Okay, you have the healthcare industry. I refer it to another initiative taken by the oil and gas sector in the exploration and production activities, where the public-private approach, if I might say so, the EITI initiative has been launched, focusing on the resource revenues, meaning that those who are in this activity will publicize the payments made to a government, and the government will publicize the revenues that it has received. So transparency, away from the, I would say, idea of legal or illegal resource revenue transparency, by definition will focus people much more on the way to behave if transparency is the rule. And what is interesting, page 10, is that this initiative has apparently got some reaction from the political side, both at the G8 summit in Deauville, but also in section 1504 of the Dodd-Frank Act, where this initiative is referred to explicitly, and where the idea of this extractive industry transparency initiative is pushed further, not just by making public the payments made to a country, but by also making this obligation to disclose on the basis of a project-by-project approach, which means much more transparency. So this is the section 1504 of the Dodd-Frank Act, still to be implemented, awaiting page 11, the SEC rules to be established. And this means that you have, page 12, a kind of tension building up between the old FCPA approach, which was more prohibition-based, limiting the type of payments, but at the same time not forcing you to public payments that are FCPA compliant, towards a new orientation, which is more the basis of 1504 section, where we have a kind of hybrid prohibition disclosure-based scheme, limited to a number of companies today, oil and gas and minerals, and therefore questioning, I would say, the coherence of the approach today. You will read at the pages 13, 14, the same approach by the European Union through the transparency directives, focusing both on listed companies and on unlisted large and public interest companies. This leads me to state at page 15 that we have a number of initiatives which are more and more creating the lecture of corruption or bribery on a country-by-country approach, which is basically transparent international, if I may say so. You have also this extractive industry approach, which is more focused on business flows, revenues, and sector approach. And this will lead to a kind of segmentation, which I will illustrate when you go to slide 19, where I have compared the Transparency International list of bribery, and where you see the country Azerbaijan, which is listed 143, so it is at the far end of the list. But by the same token, this country is a EITI compliant country, meaning that under the other approach, it is a perfect student, which leads the U.S. State Department to state in a note on Azerbaijan that there is a lot of corruption, but not in the energy sector. So you come to a kind of split approach of what is corruption about. And I think when we take the evolution also with the Dodd-Frank section 1504, we are at the recognition of a country risk, we are at the recognition of a project risk, and we are at the recognition of a business risk. And I think the only way forward is that we work on a global risk approach, which at page 21 will allow you to make a proper risk assessment, which of course today is the challenge put on companies by the legislator and by the enforcement agencies, because we have to prove, quote unquote, that we have procedures that are adequate, that we have done whatever we had to do to avoid any infringement. And therefore, I think if you read, for example, the guidance given by the UK Ministry of Justice on the UK Bribery Act, it's a very interesting way to appreciate within 2 seconds the vulnerability of your activities. If you're in oil and gas, for example, okay, you have by definition the country risk, you combine that with the sectoral risk, and there the UK Ministry of Justice itself says that one of the high-risk sectors is the extractive industry, so congratulations. You're on transaction risk with license and permits, which is at the core of the oil and gas business. You have the business opportunity risk for high-value projects involving many contractors and intermediaries. And finally, you have the business partnership risk because we have consortia and joint ventures. So just reading this agenda makes that for every sector, for every practice, it is very easy, quote unquote, to make a statement on where am I in my risk appraisal and what is the need I have to launch this kind of risk assessment, page 23, which then will integrate your internal risk and external risk and is the basis of your compliance agenda. So compliance at the end of the day goes back not only what is to be driven through because the agency says so, but is also basically the logic of your own business risk approach in a global manner. Thank you.
Thank you very much, Guido. Are there any immediate questions? First of all, not from the audience. Anybody here have a direct question?
Guido, it's John Nasikas, just interested in your view of the transparency approach that you've described. Is it something that from a qualitative standpoint you agree with? From your corporate standpoint, is that a good trend?
John, I think the question is not whether we agree with it or not. I think it's a reality that today, when you speak about risks, you need to identify your stakeholders, and the non-governmental organizations are real stakeholders. And if you read a number of these reports, for example, from the United States Department or others, the NGOs are an important source on the way to structure and to think through compliance. So the question is not whether we like it or not. The question is what is the relevance. And I demonstrate, I think, today, on the case of Azerbaijan, that it is interesting to understand the risk of Azerbaijan, but by the same token, that for certain industries and sectors, the case for that activity is non-risk. So I think that is just the reason why I would say don't look into a case in a fragmented manner. Try to identify, for example, at the page 26 of the guidance given by the UK Ministry of Justice, try to identify the global risk that is proper to your activity in a certain country, in a certain way you structure it. And I think once you do this, whatever comes later, you have already, I don't say the adequate procedure fulfilled, but you cannot today do business if you didn't have yourself already done the basic risk assessment that allows you, from a governance point of view, to understand what risk you're taking.
Okay, so no other question. Maybe John, we go on with the next presentation.
Happy to. Thank you, Annette. If we could now turn to the beginning slides. I'm here to describe briefly the long, very muscular arm of the United States Justice and Enforcement Authorities. And turning first to slide 4, I can do this in fairly quick succession, and there's no magic to this number, whether they're 10 or 11 or 14 trends. There are many, and they tend toward the more aggressive by the U.S. And starting with the trend 1, large financial penalties. Everyone here in this room and presumably on the webinar itself are aware of some of these penalties, but when you see it in chart form, you realize that these criminal fines and civil penalties are, in recent years, reaching hundreds of millions of dollars each year, and that trend, we think, in the white-collar defense community is going to continue. The slide 6 shows trend 2, the industry-wide investigations. This is something that has been an approach the Department of Justice has taken not only in the FCPA arena, but in many other areas of broad federal enforcement. It's an efficient approach, it's a successful approach, and it's an approach they're now applying with rigor to the FCPA world. You can see here we've listed technology and telecom companies, the pharma medical device area, oil and gas, which obviously Guido has just been talking about, and then sovereign wealth funds, for example. These are trends that will continue because, again, the Department of Justice doesn't want to just have one company punished for behavior they think has gone across a line, but they would like to be able to take that behavior, take the cooperation of that company, and apply it to other companies in that sector. It works well. It leads to, in their view, strong deterrence. Trend 3, here, the red and the black on the screen says what is intended here, that the top 10 FCPA settlements in size over the past few years, 9 of the 10 involve non-U.S. companies. Only 1 involves KBR Halliburton, a U.S.-based company, which again shows you that long reach of U.S. anti-corruption law. Trend 4 sounds a little bit like the David Letterman show, but if you look at the trend 4, increased prosecution of individuals, that's another area that Department of Justice views as a way of capturing the attention of corporate boardrooms and corporate executives, because it's not just the cost of doing business anymore. Department of Justice views enforcement actions against individuals as one of the primary ways of changing corporate behavior. And there you'll see since 2007 a trend upward with a slight dip in 2011 that we expect will start going back to higher levels as we go forward. But that had never been the case if you looked at the previous 5 to 10 years. Trend 5, interpretation of foreign official. Again, those of you who follow the law know that this is an area where defense lawyers are fighting back and doing their best to challenge the government, where the government is aggressively expanding the definition in the defense bar's view of what a foreign official is. there are 4 recent federal court cases that has agreed with the Department of Justice's interpretation that employees of state-owned entities can qualify as foreign government officials under the FCPA, and rejected the motions by the defense lawyers to have the case dismissed on that basis. Those cases were, for those of you who are interested, in California, 2 of them, one in Florida, and one in Eastern District of Pennsylvania. Trend 6 is an interesting one. You're probably well aware of the case involving, it's called the African Sting case, also known as the Gabon case, because there were a number of defendants that were arrested in a massive sting operation. It involved 150 FBI agents, the execution of 14 search warrants in the United States, 7 of them by the United Kingdom City of London Police. You had wiretaps, you had cooperating witnesses, undercover agents, posing as agents of the foreign government officials, allegedly of Gabon. There were over 1,000 hours of recorded conversations, over 5,000 taped phone calls. This is the type of law enforcement approach that's used historically in organized crime cases, in narcotics cases. But now being applied to the white-collar world increasingly, and in this Africa Sting case in the FCPA arena. Interestingly, that case, as again many of you know, collapsed with, I think, aggressive defense work by a number of fine firms and lawyers in a federal court in Washington, D.C. So despite the zeal of that effort, it did not succeed, and ultimately there were issues with, I think, the zeal and the speed with which the government moved. That does not mean the Justice Department will not be repeating this approach, because it does work. It does has an in terrorem effect, and companies worry about that prospect. And we are seeing increasing use in white-collar cases of wiretaps and other aggressive tactics. So don't think it's going away just because the Gabon case was tossed by the federal judge. And second bullet point in Trend 6, DOJ seeking prison sentences for persons convicted of FCPA offenses. We've already touched on it in an earlier slide. It's once again something that the Department of Justice is doing across different areas of prosecution. The cartel area, many of you here are familiar with how many individuals are being pursued, foreign individuals, to serve time in U.S. jails. You see it in the off-label prosecution area involving medical device and pharmaceutical companies, and you're now seeing it start to really press forward in the FCPA arena. Again, the reason why is simple. The government believes in the United States that it leads to greater deterrence. Once executives know their liberty interests at stake, nothing worries an executive well-educated sitting in a nice building more than the prospect of losing one's liberty. In the process of losing one's liberty in the United States, if you are convicted of a felony, you lose the right to vote, which a lot of people rightly find very important. So while there are these aggressive enforcement tactics, be aware DOJ is not infallible, and sometimes defense lawyers and companies do need to press back. Lindsay Manufacturing is the case not on this slide, but that case also recently collapsed post-conviction, and the convictions were dismissed by the federal judge for a variety of reasons that the defense lawyers had pressed. Trend 7, expansive legal theories. There, won't belabor the point, but just like in the area that we've seen before involving foreign officials, the government now is looking at just a single wire transfer in the Tenaris case, or charging Pena as an agent of its U.S.-listed customers. Again, not novel concepts in terms of how the Justice Department often can find a venue or jurisdictional thread and pursue a case federally in other arenas, but they're now pushing those types of theories in the FCPA arena. Trend 8, increased international cooperation. I mean, you can see the reason Kathleen Harris in London coming out of the SFO and Guido, from his background here in Europe and the continent, and myself coming out of Department of Justice, there is no doubt there's just increased international cooperation. The way there is in the antitrust enforcement world, we all have seen that for many years. The way it's been in the international conspiracy, international fraud case world, again, for many years. It's a common blueprint of the Justice Department, and now you're seeing it being increasingly coordinated among the in the FCPA arena with various countries, global anti-corruption units talking and coordinating their activity. Trend 8, it will also just make the point that some corruption investigations obviously can begin outside of the U.S. and then expand into the U.S. For example, the Siemens case, BAE Systems. I was personally involved in the BizJet Lufthansa investigation, and there it crossed the Atlantic Ocean from Oklahoma right to Germany, and involved Lufthansa Technik along with its American subsidiary. Trend 9. Continuing scrutiny of business combinations. That's an area that, when you look at the recent settlements, the importance of due diligence in joint ventures and mergers and other business combinations can't be overstated. The third-party business relationships that Guido touched on, that the energy sector is dealing with in dicey parts of the world, are high-risk assessment areas that we all should pay attention to. Trend 10, only 2 more to go here, at least in my itemization. The trend toward voluntary self-disclosures and aggressive cooperation. We don't need to go through the details of that. Obviously, DOJ and the SEC in the United States believe voluntary disclosure is helpful to a company. I think on the defense side, there are times when we agree with that, and there are other times we do not agree with that. Trend 11 I added at the last minute because I've seen increasing incidences and worries relating to extradition efforts by the United States of foreign-based individuals. Again, that used to be more limited toward cases involving violent crime or narcotics trafficking or other areas. Now the extradition in the economic crime area is starting to take a more accelerated path, and we worry about that all the time. Different countries have different treaty obligations with the United States, but increasingly there is that international coordination that does lead to individuals not being safe on their foreign soil. I will very quickly, because I think I've been given the yellow card, about to become the soccer equivalent, I guess, of the red card, but no doubt antitrust compliance guidance in particular can help a company out in the antitrust world. Clearly cooperation can lead to amnesty and leniency depending on the pecking order of the companies. But applying that type of general kind of guidance, compliance guidance principle to the anti-corruption world, there is increasing amounts of guidance there. Again, I think Guido touched on a number of them, so I won't repeat any detail. Understand that there's not any formal guidance at the moment from DOJ or SEC on the FCPA, but we expect sometime any day, or at least any month this year. It's been promised by the Deputy Attorney General. We expect it soon. But you can look at the DPAs, deferred prosecution agreements, non-prosecution agreements, opinion procedure releases, and see there are a number of parallels as you read through a given DPA. We've listed them out on slide 20 to see some of the particular items that we could go on at length if we needed to. There's also separately the 2008 DOJ guidance, which rather than being a specific Deputy Attorney General with a name of a memo, it's now been codified into the U.S. Attorney's Manual under their principles of federal prosecution of business organizations, with much in parallel with what you see in other guidances. But it's a helpful document to read. I actually find it engaging and entertaining, but that's because of what I do. But if you ever want to energize your evening, read the 2008 DOJ guidance in general, not just the guidance related to compliance programs. And then you have, as we turn to slide 23, the sentencing guidelines that Guido touched on. have a number of, again, similar points and questions. This is the 7-point program that the sentencing guidelines lay out. They provide reductions when you go through the guidelines analysis of culpability scores and base fines. And again, those are something that again and again companies have to look at and make sure the Guido de Klerks of the world are following and having their companies put into place. You then, I won't make the argument of the business case for effective compliance. I think it is clear, although there are many sub-issues. I also want to touch on, there is the OECD good practice guidance that has 14 measures for companies to take to prevent and detect bribery, so that you have different numbers of important points, but they all state many of the same things. Final item I'd just like to say, used to use this as a prosecutor in cases, and now I use it as a defense attorney. And interestingly, reading the UK Bribery Act guidance from early last year, the author of the lead author of the report in his foreword and then in the text of the guidance talks about combating the risks of bribery is largely about common sense, not burdensome procedures. Common sense is an important concept in U.S. law. When you're in front of a jury, the jury is told specifically by the judge they are to use their common sense as finders of fact based on their life experience and make whatever reasonable inferences they think make sense. And given that fact in a trial context, you reapply that to the boardroom, you reapply it to the conference rooms where we litigate with the Department of Justice, and you have prosecutors on the other side looking for common sense. They also are looking for a company that's acting in good faith. My last bullet point there. They're looking for counsel who have credibility and keep it, and they are obviously always looking for that touchstone of law, reasonableness in approach. So with that, those are all loaded concepts, but very important for what we do.
Thank you very much, John. Do we have any questions?
Kathleen Harris from the London office of Arnold & Porter. John, you touched on, in fact, you defined the US as a long and muscular arm for enforcement of FCPA. Many of the enforcement actions have been taken against foreign companies, and I wonder if you would see a trend in the US, and I know they're currently looking at their enforcement activity under the FCPA, whether they'd start to look inward instead of reaching outward so much.
I couldn't agree more, and just because we describe it as long and muscular doesn't mean we agree with it. There's plenty of internal corruption within the United States to pursue, and frankly now with the UK aggressively coming up with its own approach to international corruption, and other countries across the globe, Japan, Brazil, even countries like Russia and China, at least on the books, are passing laws. Will be interesting to see how they ultimately are enforced. But we also are dealing with Canadian authorities and just countries around the world. The industrial nations, I think, are starting to act in more coordination. But bottom line is the U.S. still remains a big power with a aggressive department that is succeeding in reaching across the ocean, Kathleen. But we keep trying to push back, and I think more companies potentially can keep pushing the issues. Because what we have found, when you get in front of a federal judge, the playing field evens a lot more than when you're actually just dealing with the Justice Department, which has all the power, all the discretion, frankly, all the leverage for the most part. But when you get in front of the federal court, suddenly the Justice Department is an equal player, which takes away some of their vigor.
Lovely, thank you.
Okay, I think if there are no more questions, then maybe I'll ask Kathleen to go on with the UK perspective.
Excellent. I'd love to start with the UK perspective. As I said, I'm Kathleen Harris from the London office of Arnold & Porter, and I do that for the benefit of the people on the webinar. Good afternoon to you all. John started off, and point I picked up on in my question about the long and muscular arm. I think if I had to describe the arm of the UK, I'd say it's long, considerate and realistic, and common sense prevails, and that's something that you see very much in the Bribery Act guidance. My first slide is really highlighting the objective of antitrust and anti-corruption legislation. And the key takeout from that is both the OFT, when looking at antitrust issues, have said when markets are working well, good business benefits too. And equally, when there was lots of debates about the Bribery Act, and you'll remember there was a point, or you may remember, where there seemed to be a sort of a delay in the enactment of the Bribery Act, and Ken Clarke, who was the Justice Secretary at that time, gave many speeches, but one of them that he gave to almost try and reassure markets is the confidence in saying addressing bribery is good for business because it creates the conditions for free markets to flourish. I think what you can take as the overall objective is to create conditions for free markets to flourish. And it's similar to many of the objectives and terms stated by the OECD, that's the Organisation for Economic Cooperation and Development, and also in the UNCAC Convention, which is United Nations Against Corruption, where you will see that that objective seems to run through the guidance that they have issued. I won't go through the specific offences created in the UK to deal with cartel offending and bribery. They've been talked about a lot. But what I will say in relation to the antitrust offending, laws appear to have been enacted that seek to punish conspirators. And the theory behind it is if you make the cost of conspiracy high enough, that will counteract the natural tendency for people to seek collusion as the easiest way to profit than competition. And similarly, in relation to the Bribery Act, when you look at the Section 7 offence, which is the offence that deals with corporate liability, that is effectively trying to take the responsibility away from the individual and to make the company take ownership of the issues that happen within its business. So I see that as a very sort of sensible step forward. If we move on to slide 2, I've tried to highlight the similarities between liability for the corporate offending, both in terms of the antitrust and the anti-bribery area. But in talking about those offences, I think it's important that if you're dealing with these things from a compliance issue and looking at them laterally, that it's not just those enactments that potentially create offences, and certainly one in the UK that if you were looking at issues of antitrust or anti-corruption, you'd look very closely at the Fraud Act, because there are offences there that a law enforcement body could use, such like fraud by failing to disclose information, fraud by giving false representations, or indeed abusing an abusive position. And I think it's very important when you talk through those issues and you talk through risks and you look at your compliance programme that you do try to make it laterally and that you consider the many areas of offending and not those just specific to the area that you're dealing with. And I say that that's important because certainly if you look at some of the cases and the way that they've been prosecuted, both in the UK and the US, it's not necessarily badged as bribery, the offending. You've got the books and records offences as well, and you've got the wider sort of fraud offending that's utilised. Going on to the next slide, I've tried to identify the synergies between law enforcement of antitrust and anti-corruption legislation and give a highlight of what's to come. And certainly in the cartel area, there's the proposal to remove dishonesty from the cartel offence, which again will make it very similar to the Section 7 offence under the Bribery Act, and almost to a certain degree, almost begin to make it seem like it's strict liability. There's been parallel enforcement activity by the OFT in relation to how it approaches its enforcement cases and working closely with overseas jurisdictions. And the SFO also has followed a similar trend on many of its cases by working with overseas organisations to pursue bribery and corruption and wider fraud offending. And I've listed there a few cases that are up there that will all be familiar to you. That's Marine Hose, BAE, Innospec are just a few examples. Another trend that seems to be occurring is that prosecutorial agencies and law enforcement generally seem to be encouraging reporting of the offending, and Guido touched in his presentation, he talked about whistleblowers. That's certainly an area which the SFO in the UK has been very keen to encourage whistleblowers to come forward. There was the corporate self-reporting guidance that was issued back in 2009 that very much encouraged corporates to come forward and to report the difficulties that they're finding within their corporations. And you'll see that there were a number of cases that were actually settled by the SFO where there was self-reporting. They didn't take the opportunity to prosecute. What they did is utilise something in the UK which is called a civil recovery order, whereby you can reach a settlement with a corporate body without having to go through the necessity of getting all the evidential details together. A proposal that's come forward in the UK, much I think based on the success, and I say that with a slight quirk, of the US enforcement activity, is a proposal for deferred prosecution agreements. The consultation paper was issued about 3 weeks ago and closes in the UK in August. And when you look at those proposals, it's very much aimed at trying to establish a transparent system in the UK for settlement of these types of offences that we're talking about today. It's interesting in the sense that it won't exactly mirror the system that is in the US for a number of reasons, but primarily because I think the greatest concern for the UK government and judges, the judiciary in the UK, is to make sure that any agreements were transparent, and that runs through the consultation document. The other aspect that the SFO, as I mentioned, has worked on is whistleblowing, much because, like the OFT, they like people to come in early, and certainly the OFT's leniency program is something that they have worked very hard in putting to the forefront. Whether it's successful or not will depend on business considering the risks as to whether it's worth going in early and being the first one in the door, or whether to wait back to sort out your own internal systems and then see whether it's worth coming forward and either self-reporting or indeed applying for the leniency program. Guido's touched on risk assessments, and John did too, and I think that my view on that is that it is better to look laterally at these issues. When you look at global enforcement, you cannot look at them in a narrow way. You have to look at the issue that if there's an activity by an enforcement body that is overseas, what's going to happen within Europe, what's going to happen within the UK, and how is it better to mitigate those risks. Both John and Guido have touched very much on compliance regimes, and I don't want to repeat too much what they've said, but I think something that's worth highlighting is that obviously in relation to antitrust offending, if you have adequate procedures or a very good compliance program, it doesn't necessarily mean that you will negate prosecution or regulatory action. Although it was interesting, in 2011, the chairman for the OFT, Philip Collins, gave a speech, and he stressed that it's essential that compliance efforts are designed and suited to the particular business and not just seen as box-ticking or formulaic process. That's very similar when you read the Bribery Act guidance very closely, because the key to a good compliance program is not just having wonderful documents and very, very glossy brochures. It's actually very important to show that they're living documents within the business, and that the risk management of those policies is escalated upwards and downwards. A very common trait, if I look back to my prosecutorial days, is that you would see companies with very good documentation, and you'd go and speak to the person that's responsible for enforcing those documents, and they wouldn't actually have too much of a clue what was in them, or even remember the last time that they looked at them. And I think that if you were looking at a bribery or corruption issue and you were faced with whether you had adequate procedures or not, it is extremely important to show that those policies have been reviewed and they've been updated in accordance with your business needs. And that's very different from saying that the business should become compliant. It's actually just showing that you've got good compliance throughout your business. I've highlighted here, and the benefit of going last is you can piggyback on everything that everyone else has said and perhaps save you all from hearing it again. But both John and Guido have touched in their own way on the importance of having robust systems and why it's helpful to have them. Guido talked about preventative measures, and that's very true. The prevention is always better than the cure. So I think that that's an important point to make. I think that in terms of at what stage do you engage with law enforcement, that's a skill of you assessing your risk, working closely with your compliance officer in the business and seeing what's best to go into law enforcement with. And it's always better to go in and say, I've got a problem and here's the solution, as opposed to saying, I've got a problem, come and have a look at me. On the next slide, I've looked at the sort of wider implications. I think both in relation to anti-corruption and antitrust, the aim of both regimes in the UK is to put these issues much higher up on the corporate agenda and to ensure that the corporate is proactively taking responsibility over these issues. In terms of the future, well, I've talked about DPAs in the UK. That will be a big move forward. In relation to the OFT, they've really had a mixed year in 2011. You'll probably recall that they imposed fines of nearly 50 million in its dairy investigation on a number of supermarkets and dairy manufacturers for coordinating increases in the prices consumers paid for certain dairy products in 2002 and 2003. Initially, the OFT had attempted to impose penalties of over 120 million in December 2007 and February 2008. So one can only deduce from that whatever was put forward to the OFT showed that they had worked very hard to sort of mitigate their risk and take action where they needed to, which allowed for the penalty to be reduced. I'm sure I'm about to be buzzed shortly, so I'll try and canter through the last one. I then tried to, at the end, just highlight the key challenges for the private sector. And only this morning when I was travelling over here, the UK have issued research that was issued this morning saying that the numbers of companies coming forward with information about potential price fixing by rivals has reached an all-time high. The OFT received 2,000 tip-offs in 2011, and apparently that's the highest number since current competition law came into force. In relation to Bribery Act and the corruption, I think that the move forward has been very much one to move to the whistleblowing era and to see what that will bring, and also deferred prosecution agreements to encourage people to come forward and to self-report. Many of the challenges centre around the sort of extensive jurisdictional reach of both pieces of legislation in terms of offending. And the challenge will be to have an effective compliance structure that can address the host of those issues. And I pose one question for myself at the end when you look at the trends, is one must ask themselves, in 5 years' time, will there be training contracts for lawyers or specific ones just for compliance officers? It certainly, I would say, is a growth area, and I think it's very important for corporate bodies and lawyers alike to be fully abreast of all these changes. So thank you very much for listening to me, and I'm certainly happy to take any questions.
Thank you very much, Kathleen. Do we have any questions from the phone? No? Nothing coming in the audience? Because otherwise I'm going to get a question in, if I may. Well, you've all talked about we need to look at matters laterally. The enforcers at some point do. Compliance structures need to be lateral. One thing that I encounter more and more and that's a very pedestrian practical thing, is that people want to do audits, in particular when they buy a new company. Because very often they will be responsible as the new parent, and yet they don't have a clue after the due diligence what there is hidden in the company. Have you experienced synergies between auditing in antitrust and corruption there? Or maybe you would say, well, let's not do that, we'll cooperate later, Guido? I don't know. And in a way, that is a question to all of you, I think. Who wants to speak first?
Guido de Klerk. I think the audit in case of a merger or a takeover is a very critical agenda, because it is today common practice that especially in the UK and the US, that whatever is discovered later becomes your responsibility, and recent cases have shown that the one who's doing the takeover is maybe viewed as an actor on the criminal side. So the challenge is important because the sanctions are very important. So to approach the question of audit is a very tricky one. Because the way you deal with your counterparty, which will be later on part of your joint venture or your company, needs to be based on respect and at the same time be professional. So I think the evolution in the due diligence side has become more sophisticated, but I think we need to make sure that when you are moving, except when you go for a hostile bid, when you move in the arena for a transaction that should be a long-lasting partnership, you should be marrying the professional approach on the risks that you need to take care of on the one hand, and the business-like balance on the other hand. So the role of outside counsel to work on these issues through a investigation or analysis due diligence with a report to the company that is launching the takeover, may be a way to filter, I would say, at least in the reading of the company that is doing the takeover, the risk as such. So going in yourself to try to assess directly the risk may be not the psychologically speaking the best way to approach. So there is a way to structure through outside counsel approaches to understand the risk as such. And I think also in certain industries, a lot of these projects, the main core of the agenda business-wise has been structured, for example, by project financing. So it means you have a lot of other actors being present over there, not excluding completely the risk, let's be clear, but clearly creating more transparency. And then finally, the question is, when you do the takeover, are you willing to take the risk based on a simple approach that I've outlined with the 5 criteria? Are you willing to take the risk of acquiring business in certain countries with certain features? And today there are companies or there are businesses that have decided for themselves not to be willing to do an acquisition or to acquire businesses in certain jurisdictions. So some are coming forward with a very straightforward position and imposing even on the company to be acquired to carve out certain of the activities. So I think things are changing. The liability imposed is very high. Okay, you know also that you can negotiate with your authorities the fact that after the acquisition you will have 6 months to do the complete review, based on which you will come forward completely with the findings and then negotiate. You don't have the security, but then negotiate with the enforcement agencies the profile of the risk you have acquired, and which of course is your liability.
Kathleen, do you want to?
Yeah, I was just going to come in behind Guido there and say that in terms of sort of auditing, I think you've got sort of two key issues you have to look at. One is the role of your internal auditor in terms of a takeover and the risks that they analyse, but also the fact in relation to external auditors who both actually will have responsibilities in the UK to their professional bodies. And one thing that was very interesting, I'll probably use a BAE case as an example, is that the auditors came under much closer scrutiny by their professional bodies. So I think that if you're looking at it in a sort of takeover or sort of merger acquisitions position, that you, again, in terms of sort of doing your due diligence, you would have to be also mindful of the risk of external action against your auditors yourself, and be able to do your due diligence that you conduct in a very transparent way so that you have the appropriate records to show at the appropriate time. And in terms of auditing, it comes up very regularly in bribery and corruption when you're looking at third parties and the use of agents, and what function the auditor should have in that process, and whether that's something driven very much by the sort of business delivery arm of the business, or whether it's looked at sort of holistically and included the auditing details there as well.
I would just add that successor liability is an issue that is troublesome for companies and for outside counsel. When you see a strong economy leading to increased merger and acquisition activity, the field becomes just ripe for Justice Department to probe, and the kinds of companies that we see get so quickly into the deepest trouble are those who grow too quickly without the appropriate auditing, due diligence internally and by outside firms. And it's not just in the anti-corruption area or the antitrust area, but it's in all areas of federal kind of law enforcement. The companies that grow quickly often are really motivated by more by the monies and the profits than they are by the regulatory functions, and it leads to lots of work for the defense bar. So in a certain sense, it's okay, but it's not smart business.
Your question?
Yes, I do have a question, both for John and Guido. In the US, sort of antitrust competition law violations are enforced both at the state and federal level by both the public prosecutor and in terms of private litigation. If there is private litigation, is that something that you see law enforcement taking into account or not?
That's John Nasikas. I'll just quickly jump in. It doesn't seem to slow down the Justice Department. They often know there is other litigation. You often on the defense side will argue that the company is already being significantly punished or faces real exposure at a later point. That tends to fall on mostly deaf ears when you're dealing with federal prosecutors, although it is part of the overall presentation and the ultimate balance in terms of the equities of a given action. So we make the arguments, but I must say, Kathleen, they often are looked at as secondary to the primary enforcement activity.
In Europe, of course, you will have a much more larger spectrum of approaches, but basically speaking, today, I think it depends on compliance, whether you are compliant. I would say in the bribery cases today, Europe is still struggling with coming to terms with the compliance on bribery. I think we have a much better understanding on how to cope with your question on the antitrust agenda. I think there is nevertheless the question also much more on the forefront today, whether we will pursue with decriminalization or whether we will go more in kind of either what you say, the deferred prosecution agreement, so more move into the approach in the United States, but and you know it better than myself, with a position taken by the court that a judicial review remains an issue of due process. So I think it depends on the matter where we are today in compliance. If I compare this bribery, antitrust, but there are also other risks of compliance, for example, money laundering and so on and so forth. So I think we have to look as a company for each of these domains to see what is the statement made by an enforcement agency. What is the maturity, I would say, of the other persons involved in compliance for a sector, for a certain legal domain? And it is clear that in certain domains we are not today, neither the private sector nor the public sector at large at terms with the way to force compliance. And I think that debate in Europe is a debate where we may move faster in certain areas of compliance and very slow or not at all in certain other areas of compliance. And so I think it is a painting at the end of the day that will have many colors and which makes that if you speak to your board or to your management will render things extremely difficult for them to understand how to handle this compliance agenda. And I'm trying to come to what I call to terms with that by presenting something which resembles the painter Polyakov, which means we have patches of colors, and each color has of course a certain weight. Red by definition is a high risk. By just stating the objectives and then try to see what action will be the most leveraged one to obtain to get to the objectives. And I think this is a kind of very easy way to address issues, which I think more or less, if you approach it from a management way, allows a group to say, okay, whatever the compliance arena is, there is a way that you can identify for each domain, legal domain for which compliance is required, basically these actions that are the most to be leveraged to make sure you can realize, you can come to terms with the objectives as stated by an agency. Okay.
So we have a question on the floor. Do you need a microphone? There's first.
Thank you. Eric Pijnacker, De Brown, Netherlands. I have a question to Mr. de Klerk in his personal capacity. Just a hypothetical situation that in the context of your internal reviews you're confronted either with a case of bribery or with a case which constitutes an infringement of the competition laws. I just wonder whether, in light of the differences in legislation that exist in enforcement practice, for example, the presence of the possibility to obtain immunity if you go in first to the European Commission and many of the national competition authorities, whether that would make a difference in your assessment as to whether you would voluntarily approach the authorities or not. Do you see any differences between the anti-bribery legislation, in particular in the UK, and competition legislation in Europe? Or would your approach be, well, it doesn't really matter what exactly the framework is. From our perspective, we would normally always give in ourselves, basically.
Well, I am first of all, I speak in my personal capacity, so let me be clear that tomorrow I would like to read in the newspapers a statement concerning the group. I am not today at terms with coming forward the self-disclosures and even maybe a merit. Okay, and why is this? Because I think today we are confronted with enforcement agencies that have a clear stated objective of I will enforce, you come forward. The way you come forward is full cooperation. Even if you have full cooperation, meaning you open whatever document there is, they reserve the right to go further, to pursue whatever. So their idea is, I put it a bit bluntly, but the way you've presented certain Far West situations like criminal organized crime, we are today perceived as organized crime. Okay, and that's not a judgment. It's the way the approach goes today. There is no dialogue today on how to come to terms with this issue of compliance. I'm convinced myself that the compliance issue, we start today discussing compliance. We are not at the end, we start. We try to bring together around the table people who are stakeholders in the debate. And as long as the debate today is that you're confronted with an agency that is taking a privilege, taking actions, making judgments that are more and more contested in court, and court rules in favor of the way this has to be done, making an assessment is first of all case by case, but as a matter of policy, personally speaking, going in with an agenda by just saying, I come with my self-disclosure, I will cooperate, I have the cooperation credit, okay, whatever that may be, without having a balanced approach to the issue, I think we are at risk. And I think a number of cases have shown where companies have coming forward. Either they were very selective and they got the credit not because they were cooperative on their own agenda, but because they were identified as being the way to penetrate a complete business sector. Okay? So today what is the idea? If you go forward, it's not only what is your own risk, it is also what is the sector risk. And there you go beyond what is the case. So I try to communicate around this theme by just saying who are the stakeholders and let's come to terms. I was an expert on the OECD round table that was organized 2 years ago or a year and a half ago with the OECD on corruption, and we were two persons representing the business, somebody of Shell and myself. And we were with about 50 or 60 enforcement agencies. And if you read the line of thinking, it's criminalization. And to the extent I did identify a number of cases, but today I think if you read as a lawyer, either the civil or the common law practice, and you see the way they put aside all these things that we think are one way or another acquired in our legal system, they take today the privilege to say, no way, no way. So I am hesitant today, whatever the benefit may be, to come forward unless you understand, and we understand, that we have a side, on the other side, a partner that is willing to review and to assess and to understand what's happening. It's not saying we don't take any responsibility. We are responsible, let's be clear. But I'm not willing to advise today to say there is a benefit which outweighs the risks. And not that it is because we have something to hide, no, just because the process, the due process as such, is not clear today.
Thank you very much. Was there another question from the floor? Because otherwise, John, I know you had more to say on a topic we didn't get to at all, which was the one, well, what happens if the compliance didn't work? That is to say, what do I do once an investigation has started? Should we move over to that?
That actually is an awfully big topic and maybe subject for the next program. But it's obviously important, as Guido has said, and Kathleen, I think we've all talked about, every case does depend on its own particular facts and certain legal issues that arise in its context. I did think, in response to what Guido was just saying, we have seen examples where very active cooperation, remediation, enhanced compliance, even after the investigation has gone public and the company is trying to respond, can in fact at the end truly lead to a much more lenient result. I mean, the BizJet Lufthansa case, it was right in the settlement agreement where the Justice Department said because the company had acted aggressively toward the management and fired them, had really cleaned up house, had cooperated extensively and ultimately enhanced their compliance functions going forward. Not only did they get the benefit of a 5-level decrease under the culpability score analysis under the sentencing guidelines, they also, the Justice Department, just exercising its large amount of discretion and judgment, decided on top of that to give a 30% reduction in the criminal fine amount. And that just is something that presumably that was just done based on reason and argument and advocacy, where there was kind of a mutual agreement that type of corporate positive behavior should be rewarded beyond what some of the crossword puzzle rubrics of the guidelines suggested would be the result. So that's an example of true success. There are plenty of other cases where a company will respond very quickly at the beginning of an investigation in proactive ways with the government, which is often something you do want to do, get those lines of communication going. And there are many cases that aren't reported because, frankly, they go away. There are plenty of instances where you can actually convince the Justice Department not to pursue a criminal case against the company or not to pursue a criminal case against any of its individuals, even if the company is settling. And there are all sorts of variations of that, but those are our greatest successes. A little bit like the CIA, the stars on the wall in our law offices are the stars for cases that no one reads about. Often the case that you work on that people do read about, you really wish they weren't reading about. So there's a lot of good work to be done, and I do think you often read in the literature about the differences between the UK Bribery Act and the US FCPA law, and you read about the differences of this matter in the continent versus how it's maybe being handled in Asia. But what I see, and kind of frankly preparing for this session today, is how much commonality there really is in the thinking and the reasoning behind what these, I think, major countries are trying to do. So to me, there's hope at the end of this legal tunnel that it is not all gloom and doom, but it is treacherous, it is tough, but there is incredible advantage to, I think, working as cooperatively as the case justifies with the Justice Department. And if that doesn't succeed, there is always the opportunity to fight back and go to court. And that is the right that we all have. And some companies that have exercised it, and I know we've been involved in cases where we will sue the government in the middle of an investigation for mishandling privileged information. We challenge the ethics of the prosecutors aggressively. We will file First Amendment constitutional challenges that will go to the very heart of the government's authority to bring a particular action. So there are ways to think creatively and aggressively, and even sometimes rely on the Constitution to, I think, level the field further.
So I was just going to come in on that sort of positive note, I think, but I can certainly speak that there are a number of cases which I have discontinued, which I'm sure would be newsworthy had they proceeded, because a prosecutor in the UK has an important independent judgment to exercise, and certainly the public interest cannot be underplayed in these situations. And there are many circumstances that I've seen over a fairly long career in law enforcement whereby, although the evidence is strong, actually I didn't believe it was in the public interest to prosecute. And one of the strongest sort of factors there is the remedial acts remedial action that's been taken by the company the minute these things come to light, the way in which they negotiate with the prosecutorial body, bringing attention to actual salient facts as opposed to sort of box loads of material that are completely irrelevant. And I think that in terms of sort of enforcement around the Bribery Act, something I like to say from the UK, because frankly I don't think enough of it is out there, is that the Bribery Act did not introduce new individual offending. It modernised a law that was 100 years old and brought it up to date. The extraterritorial application of it in relation to individual offenders has been in place for somewhat now nearly 10 years. And actually the new offence was the corporate offence, but even there you have the idea of the adequate procedures, and a lot of the commentary is, well, you know, how can you have adequate procedures if you end up with a live open investigation? And I always like to think that, you know, look, even if you are a banking sector heavily regulated, you'll have circumstances where someone finds a way around those regulations. And what it will call for, as John was leaning to, is a very sort of sensible, I think, reasonable, pragmatic approach to the issues. And I would say that certainly that's been the most success I've seen if you're negotiating with law enforcement, and you need, because there has to be that thread of reasonableness. And in the UK, just finally on that point, Guido's touched on judicial review. Certainly in the SFO, I think I defended about 9 judicial review proceedings. It's very commonly brought to challenge public bodies. But if they've done something that's unreasonable or disproportionate, then it's right for a corporate to do that. And I think what you're seeing more of in the US is what you didn't see is more challenges being brought about the lawfulness of the action, because I don't like to see it as an aggressive regime, because frankly that's not what the law is there for.
Thank you very much. Any last question? Because otherwise I could give we can all have a drink. Not the people on the phone, unfortunately. Well, they can have drinks too, yes. Yes. Otherwise, is there a 1-minute statement from each of you, what you would advise companies? Because, of course, the problem is we have heard such varied aspects of this pretty complex area. It's going to be very difficult to say, because we have different rules everywhere. We have 2 complex areas. We have different types of benefits for behavior of companies. So sometimes we have immunity, sometimes we have a benefit of having a compliance program, sometimes we don't. The laws are different. Other than trying to comply with every law under the sun, which is always difficult, is there a 1-minute advice?
Let me try to state in a few words. I think the bribery and the antitrust matters have become global. Okay, so I don't think today the idea is are you in 10 countries and are you trying to comply with the 10 legislations. No, the idea is what is your global approach to the issue by taking, if need be, the most severe test. Why do I say this? Because okay, we have the question of extraterritoriality, but okay, let's be clear. The US will find the way to get after you by the extensive interpretations they have. I mean, there is no way, if they would like to get after you, they will come after you, and they will find the legal way to bring you to court in the United States. So I would say, I will put aside maybe too voluntarily, but the idea of being protected. So we are exposed in a global approach, and hence I think the test to be applied will be the most stringent test that is available in the market. Okay, it may be today that is more the UK Bribery Act as a guiding principle than the FCPA. but you cannot carve out the FCPA. So first of all, it's a global approach. And secondly, I think it is a management approach. We didn't touch on the compliance officers, but they are facilitating the agenda. It is at the end of the day management that has to integrate in its reading of the business case compliance not only for health and safety, but compliance with this kind of regulations touching on anti-bribery or corruption or antitrust. And so the idea is to look into the agenda of, and this is the Siemens case is very, very clear on that. If you read the Siemens case afterwards, I mean, the way that they have addressed the question of high management and middle management and the way they work today on the management approach, apart from the fact that they have an enormous machinery put in place on the compliance, but it is a management issue. And so if you take two elements, a management issue on a global agenda, I think for a company, okay, the rest is technicalities. The rest is the way to approach, the way to read specificities case by case. But I think the key axis for me, the main lines of thinking are very simple and very clear.
Thank you very much. I don't know whether you...
I'm going to be short and hopefully very sweet. I think my advice would be is that business should not allow compliance to become its business. I think it's very important that what it should show is strategic and operational management over those issues from the board up all the way down, so that if you're in the unfortunate position of finding yourself at the end of a law enforcement investigation, you could show your strategic and operational response.
Thank you.
And I would make the final common sense point, given the complexity and evolving laws out there and how hard it is to stay abreast of them, I would rely, as obviously Guido's company in its sophistication does internally on the compliance function and the legal function. I think that's obviously important, and we can't help but boost ourselves, I think, on the outside arena. I think having outside counsel also objectively weigh in on the operation of the given company before problems occur or once a problem occurs. Normally that's when I get involved, unfortunately, is after things have started breaking apart and the enforcement action has started. But I think, again, if you can look at yourselves internally very objectively as possible, but bring in that outside advocate, because frankly I know the Justice Department views this very clearly. They do not want the company in-house counsel and compliance people be the ones responding to the subpoena or the letter request, because they don't trust them because they don't think they're objective. And if those people stumble, even inadvertently, in the production of certain documents, in the retention of certain records, or the lack of retention, or the misstatement made in a particular response, the government takes a very dim view of that and views there have been intentional misconduct by the company, whereas if Kathleen or I make that misstatement or miss that document in a production, it's viewed as inadvertent error, because hopefully we have a good enough track record that the 99% of the other work we're doing is accurate. So I think that's a very important concept that companies have to understand. They often stiff-arm the internal counsel, I've seen it, but when they don't allow the outside counsel to handle the communications and the really direct conversation with the government, they tend to get themselves in more trouble, at least in the United States.
Okay, thank you very much. Thank you, first of all, to the panelists, and thank you to the audience, because we still have, it was a very long time that we discussed, many different topics. We haven't had that many questions from the participants on the phone, but again, feel free to send in questions later, because our panelists are very happy to respond. Thank you very much.
That imposed on us the way to structure internally matters of preventing and detecting, and by definition ending infringements. And therefore, I would say the way to be effective, because the effectiveness is the test that is today the key parameter, and those who are familiar with the position paper by the European Commission on competition law, the Commission has stated effectiveness is the sole benchmark of success. So whatever you do, forget about the rest. Effectiveness meaning, gentlemen, ladies, no infringement whatsoever. So you have this position taken by these compliance agencies, pushing us to mirror their expectations, their objectives, to make sure that at the end of the day, our behavior leads to no infringement. And if we look into this concept, less value-driven and more enforcement-driven, it means, at page 5, that we come to some of these, I would say, boundaries of where we are in the legal system, because this enforcement approach challenges more and more established legal concepts, necessitating, in my view, a much more pronounced legal review, legal oversight by the judicial, by the courts. A few illustrations. In the deferred prosecution agreements, the question to impose corporate monitors rather than asking management to do the job with reporting duty. The extensive interpretation of the parental liability, especially in the European Commission's reading. Page 6, what is common to both the antitrust and the anti-bribery, especially in the United Kingdom, but also in the United States, the focus on individuals, leading to incriminate individuals, directors, officers, without having today any criminal liability on the company. So a very focused approach on individuals. And then an issue which I think is at the heart of the agenda, the fact that today we are credited for cooperation the moment we see or we identify an infringement.
Going to win the bid, and then they dealt with the various public officials to make sure that the winner would actually win. So not only did we find that out when we looked at all the documents, but we also found out very soon that the whistleblower in the cartel case had done some major cleaning up and had self-reported to the authorities also on the corruption side, which meant that the corruption of the others also was found out, and they thought at some point this was a very big conspiracy to kill the other industry participants. I think it was mostly because they had a new general counsel who was cleaning up the business. But whatever it was quite impressive, because I counted something like 27 investigations, about half and half corruption and cartel in basically the same matter. So, and of course now in the meantime, when doing seminars on compliance, I also find that most of the company representatives have a huge amount of experience in anti-corruption matters, and that the two investigations really tend to go together. But finally, let's get to our speakers. We'll hear more about the links between those two areas, first from a somewhat philosophical standpoint, then learn about recent enforcement trends and international cooperation, and get an overview of the synergies between antitrust and anti-corruption compliance in the US and the UK. So Guido, would you like to start on the in-house perspective?
Thank you so much. Good morning, good afternoon, wherever people are located. Privilege for me to address these issues, which, as you will read, are only my proper views, my own views. I will not run through the presentation as such. I will highlight a few points so that you can try to see how, I don't say philosophically, but conceptually, I try to come to terms with compliance. I will focus on the concept of compliance, try to indicate the impact of the compliance approach on some legal concepts, necessitating judicial review. I will try to balance between enforcement and transparency, to make sure that we, at the end of the day, understand that the integrated approach is a mandatory approach which leads us to the way we should structure as companies the compliance programs. On slide 1, I have tried to indicate the basic concept of compliance, which in my reading is less related to values, but more related to the way companies should structure their behavior in line with not only legal requirements, but especially the position taken by compliance enforcement agencies. So my basic position is whatever we do, we are today confronted not only with the legislation, but by the way this legislation is read, interpreted, and applied by the compliance enforcement agencies. And if we take that for granted, quote unquote, at slide 3, I then would say if we have this enforcement focus and enforcement agencies, what is their main concern? Their main concern is the behavior offenses, the way we behave both in corruption cases but also in cartel cases. And I think that is a very important way to approach compliance, although I'm not a behaviorist, from a behavior point of view, because at the end of the day people will look into the way our behavior has been structured in line with the way the enforcement agencies ask us to behave. And hence it leads us to what I would say a managerial approach. Compliance officers are important, but by the end of the day it is middle and top management that carries this burden, with a tool that is basically the way we should behave, i.e. self-monitoring and self-assessment of our conduct, which is both the case in anti-corruption and in competition law matters. From an internal point of view, I would say, and this is a kind of selling line, if we can do business because we have to comply with health and safety requirements, business without human casualties, we should by the same token do business without compliance casualties. Once we have this approach from an enforcement point of view, the question is how can we structure our compliance agenda? And at slide 4, I try to identify the key issues. Compliance today is not just obedience with law. It is more than that. It is also that we have to prevent and detect the violation of law. So we are becoming really private enforcement agencies in line with the way public enforcement agencies look into these matters. So this is a very enforcement-driven approach.
Examining you afterwards. Now to our speakers. We're very privileged to have among us Guido de Klerk, who is Deputy Secretary General of the GDF Suez Group, where he oversees the group's global compliance policies and organization. Before taking on that role, Guido was Group GDF Suez's General Counsel. But he has not always worked in a company, I saw. Actually started out teaching law in Leuven and also worked as a private practitioner. And he speaks and publishes regularly on compliance matters. So the perfect person to ask questions to, I think. And we're very privileged. We're also very happy to have Kathleen Harris, a London-based partner in our white-collar criminal defense practice, where she represents companies and individuals in criminal investigations and compliance matters in complex economic crimes. Kathleen also advised government ministers on the development and implementation of policy and fraud strategy and leading complex overseas inquiries and analyses. Before joining Arnold & Porter, Kathleen was on the other side. She actually served as head of the fraud business group and head of policy at the Serious Fraud Office and was senior strategic policy advisor in the Attorney General's office. And last but not least, we'll get to John Nasikas, the global chair of Arnold & Porter's white-collar criminal defense practice, who concentrates on complex parallel criminal and civil litigation and internal corporate investigations. He's been in Washington for about 30 years and has advised and defended companies, executives, as well as employees in a wide array of federal and state criminal investigations. Recently it's focused on FCPA global anti-corruption, but also antitrust, healthcare fraud, government contracts, international trade, export control, and public corruption. John's also been on the other side and was at the Department of Justice previously as an assistant U.S. attorney for the Major Crimes Division of the U.S. Attorney's Office for the Eastern District of Virginia. So after all these lengthy introductions, let's get to today's topic, compliance in anti-corruption and antitrust matters. For me, this is a really interesting topic. As I say, I'm an antitrust lawyer, and I've been working on cartel matters for the last 20 years. And my own exposure to corruption came in the first real big cartel case where we were mostly dealing with bid rigging, and bid rigging around the world. And I was working on the cartel side, but very soon we realized that the cartel only worked because there was also corruption. Basically, the guys got together. They decided who. Thank you very much, and good afternoon. Welcome to all participants in the webinar on synergies between anti-corruption and antitrust compliance. My name is Annette Schild, and I'm a partner in the Antitrust Group of Arnold & Porter. I can tell you right away, I'm the only antitrust lawyer around, and so I'm the one who very much looks forward to learning from our colleagues on the panel today. Before we start off, I have a few housekeeping matters, unfortunately. First of all, to those in the room, I should tell you that our microphones are extremely good. We've tested them yesterday, and so if you have phones, I would really ask you to turn them off, because otherwise more than 100 people around the world will listen to your phone call. Then the second, speaking of sounds, I should also warn you, we have organized a very good system to make sure that our speakers don't speak so long. So we will have the bells ringing at the cathedral every 15 minutes. So they know that they are out of time when the bells are ringing. So don't get scared, the people on the phone won't hear that, but just be prepared. The next one, our program, we're really hoping to have this as interactive as possible. So the idea is that we'll have 3 relatively short presentations of roughly 15 minutes each, and then have time to discuss after that. Since the participants in the room here can continue talking to the panelists later, if we get in a lot of questions from the audience on the phone, we would ask you for your understanding that we'll treat those first, because all the panelists will be there later and very happy to answer additional questions. We'll have 2 rounds of questions, one after each presentation, and there I would ask you to limit your questions just to questions of understanding of the presentation, because we're hoping that maybe some other questions we'll answer in the other presentations. And then we'll have a longer period of time after I think around 5:30 after the 3 presentations. Questions from all the participants via the webinar can be typed in, and we'll do our best to respond to all of them. If we do not manage to get through every question, we'll get back to you later. One of the panelists or several of them may answer those questions. Final housekeeping, I know some of you will need CLE or CDP credit, and that means that we will have to send out a questionnaire with a few questions afterwards, because that's the condition for getting that credit. So don't be afraid, we're not